dipped into the Discovery on Maine.
I've heard about it.
You should.
Yeah.
Yeah, I listened to the interrogation 2 nights ago and I was blown away.
It's wild how calm he was after seeing the video.
Yeah.
Like, I had the opposite of hearing the interview
Right.
and then see how calm he was in body or in the interview.
Wow. And then see what.
Insane.
Wow.
All right. Podium mic. Testing the podium mic. You hear me okay? Perfect. All right. There it is. All right. Judge microphone 7. Judge microphone 7.
3 minutes of what's called protected time.
Judge microphone 6.
Yeah, but okay. Yeah.
So it's this, you know how
Judge microphone 5.
I'm probably not going to take it.
Judge microphone 4.
I'm like,
I mean, I have a little thing
Judge microphone 3.
saying
yeah.
they want to start asking questions.
Judge microphone 2. And judge microphone 1.
Yeah.
Like almost just.
Yeah. Your reply brief really did seem to
All persons having anything to do before the Honorable Justices of the Supreme Judicial Court, sitting at the Law Court in Portland within the state of Maine, may come forth and declare it, and they shall be heard.
Good morning, you can be seated. The matter before the court is Cumberland 25-454, State of Maine versus Ali. And I see counsel are present. I'm assuming you're ready to proceed. The matter is being streamed on the web, both by audio and by video. Before we begin the argument, I'd ask counsel to please introduce themselves by saying their names for the record, together with the party you represent.
Attorney Pam Wentworth for Mr. Ali.
Assistant District Attorney Kristen Hughes for the state.
Thank you. And Attorney Wentworth, if you're ready, we'd be happy to hear your argument here this morning.
Yes, Your Honor. May it please the court. On March 20th of 2025, this court reversed the trial court's error in not merging counts 1 and 2 and mandated that Mr. Ali be resentenced. Instead of following this court's mandate, the sentencing court ignored the new evidence that was presented at the hearing and used the exact same sentencing analysis that it had done in September of 2023. This is clear error, an abuse of discretion, and ignores the clear directive of this court. The sentencing court, specifically said, quote, "I maintain the same analysis that I did years ago when I first sentenced you." And that's in the appendix on page 28. Evidence at that hearing.
Counsel, I see the green light's on. Can I ask you about, this court did say that, but then at the end of the hearing, I think at the state's prompting, the judge also said, I maintain the same Huey analysis. It's consistent today, and I wouldn't change that. Does that in any way cure what the court might have said earlier about, I'm not going to do resentencing? Could we read that as the court said, well, if I were going to analyze it again, it would still be the same Huey analysis?
No, Your Honor, because I think that this court's precedent is clear that it does need to go through those steps again. New evidence was presented at that hearing. Also, there was intervening precedent in State v. Ellis that also should have modified the court's original analysis. And so that does not cure it, both because it didn't go through the actual analysis, and there was also new evidence and intervening precedent that should have changed its analysis.
Well, can we break that down into two? Let's assume on resentencing, the court says, I don't see anything's different. Here's my Huey analysis, and basically reads from the transcript what they did before. Is that good enough?
No, I think it would have needed to address those points.
Well, so what you're saying is, but then they need to address, that's a separate issue, isn't it? Whether there are some additional facts that have occurred since the original Huey analysis was made? In other words, if there were no additional or different facts to be considered, couldn't a court just say, my analysis isn't changed?
I don't think that's necessarily relevant here because there was new evidence.
I understand.
And there was new precedent.
And so I'm trying to say, what I'm suggesting is those are sort of two different, slightly different issues, whether one could simply adopt the same analysis versus whether there is new information that needs to be considered.
I suppose that's somewhat of a distinction, but I do think that, again, also in this case, it couldn't rely on its first analysis because this court merged counts 1 and 2. Step 1 of its Huey analysis in the original sentencing involved Mary Smith, which was part of the merged count.
Well, step 1 of the analysis in the original Huey sentencing was really focused on the more serious, which is a process we have certainly condoned, focused on the more serious and what the facts were of the offense.
I think that was the main focus, but it did still consider count 2 in its overall sentencing scheme. So I don't think that it could separate those out and then just rely on the same exact analysis. And regardless, there was new evidence. There was also this court's precedent in State v. Ellis, which said that absent record evidence, it couldn't decide that there was a lack of remorse just because someone took the case to trial. In this case, in Mr. Ali's case, in the first sentencing, the court did find that he had a lack of remorse, but there was no evidence within the record to support that finding outside of the fact that he took it to trial.
Did he testify at trial in the first trial?
He did not.
Did he allocute at sentencing?
He did allocute sentencing.
And the court could, as consistent with Ellis, a court can base a lack of remorse or taking responsibility on an allocution.
I don't think that's what this court did, and Mr. Ali was incredibly emotional and, in my opinion, was allocated very well at that sentencing hearing. There were multiple people in the gallery that were tearful, so I don't think that's the basis of the court's finding of lack of remorse.
Counsel, do you read our merger jurisprudence as requiring a entirely new sentencing every time? Is that what you understand it to be?
Well, certainly when the court mandates a resentencing, I expect a new sentencing, yes.
So resentencing to you means we start from scratch and we do a whole new Huey analysis. Is that how you've interpreted our cases?
I think that's what this court has said.
Doesn't that create an anomalous result between defendants who are sentenced, go to prison, serving their time, and those who get resentenced? When they come back for resentencing, they can run up their good behavior in prison, which the others can't, obviously, and having realized what got them a longer sentence the first time around by saying something or not saying something like, oh, I don't want to make that mistake again. So they get to do a do-over, whereas other folks who are simply sentenced doing their time don't get such an opportunity to have a second try after having been pointed out what they needed to do in the meantime.
I mean, the court made an error in not merging these counts, and then it had new information. I don't know why the court would have to blind itself to this new information on a resentencing. And this court's precedent has said that aggravating factors, such as new convictions or other specific events, could up the sentence.
I realize that's the rule. I'm just wondering if that creates an unfairness.
I don't think so, and in fact, I think we should be encouraging people to have reasons to be on good behavior while they're in custody. And so I think that, frankly, that's a good thing, and maybe really what the court's concern is that there's not some other mechanism to address people who may have had good behavior during their time in custody. That might be something for the legislature, and perhaps that's a policy change. Maybe there should be periodic review to incentivize folks like that, but that's not what we're here for today.
It's called parole.
And it would be great if the
We
legislature
heard the commercial.
Can I ask about, I understand you want a remand for a new sentencing. You suggested that we should, if we were to do that, instruct the court that it must reduce the sentence because of the finding of remorse. And I'm a little puzzled by that request. I mean, it's certainly one thing to say a court has to consider information, but to dictate that the court must weigh it some way. So can you explain to me a little bit why you think we would have the authority or responsibility to tell the court it must reduce the sentence?
Well, I think this court has the authority to tell the lower courts what it must do, and I think that I have not identified, nor has anyone from my position identified anything that would justify keeping it the same. Perhaps there are those reasons. I haven't identified them.
Well, couldn't the court say, it's great that you're doing well, and that actually indicates to me that my original sentence is doing what I thought it would do. And so for all of those reasons, I'm going to take into account the new information you've told me, but decide that, XYZ is still the appropriate sentence.
I don't think that's actually going through the Huey steps, though. That's
well, assuming the court did go through the Huey analysis.
That's ending up reasoning from the conclusion, because if you take step one, you have this Mary Smith issue where they considered count 2 in step 1. I think that has to then reduce step 1 of the Huey analysis. I've not seen...
But when we say that you have to consider factors, we don't say how much weight you have to give them. In other words, a court may identify in step 2 of an analysis mitigating factors and aggravating factors. And we can talk about whether this really is a mitigating factor or not, or whether something really is an aggravating factor or not. But we don't tell the sentencing court how much weight, if any, to give to those in either increasing or decreasing a sentence, do we?
I think any court would be hard-pressed to logic out how these three things that we've identified at each step of the analysis, how it would not somehow reduce the sentence. I think some weight has to be given to each of those things, and that leads to this sentence needs to be reduced from what it was.
Well, in this particular case, you made a specific, or at least the counsel for the defendant sentencing specifically requested the court to consider, or at least indicate how it was taking into account the new information that had been provided. Is that correct?
Correct. The court didn't address the new information whatsoever, and so maybe there is some, and I think I put this in my reply brief, there might be, theoretically, some cognizable reason to keep the sentence the same. I don't think it's anywhere on this record. The court didn't provide any of its reasons, so I just don't see how the court would not reduce the sentence, but we're not even at that step because the court didn't go through the Huey analysis.
Counsel, are you saying that even though counts 1 and 2 were merged, are you saying that the conduct reflected in count 2 is irrelevant to the sentencing?
I think it would be then a step 2 analysis. It shouldn't be in step 1. And regardless, let's even throw that piece of it out. You still have issues on step 2 and step 3 in terms of, again, the court's clear finding of fact that Mr. Ali at this sentencing, at the most recent sentencing, was remorseful. That was a huge aspect of the court's analysis in the first sentencing, was his supposed lack of remorse. So the fact that you now have a contrary finding at this point is, I think, very instructive. And then you have how well he was doing at the prison, showing that his prospects for rehabilitation are much better than they were when the court sentenced him originally in September of 2023.
Those are all considerations that the sentencing court would weigh, but the conduct still in count 2 is a relevant factor at some point in the sentencing process.
Ultimately, those counts were merged, so it's unclear to me how the court should weigh those factors in step 1, because he was only convicted of count 1, nothing to do with Mary Smith, and so the fact that those were mentioned, I think the court needs to sort of parse that out.
But you're not saying the court can't consider other conduct in the context of a step 1 of the Huey analysis, are you?
Well, the court can only consider what he's been convicted of and the conduct within that conviction.
Well, that's not our jurisprudence. Our jurisprudence is that the court can consider factors so long as there's reliable evidence of it, even if he was not actually convicted of it.
I think step 1 is more what the offense of conviction is. Perhaps under step 2, I think that's correct.
Additional questions from anyone? From the bench? Thank you, counsel.
Thank you.
Attorney Hughes.
Madam Chief Justice, Justices of the Court, my name is Kristen Hughes, Assistant District Attorney for Cumberland County on behalf of Appellee State of Maine. Appellee respectfully requests that this court affirm the sentence in this case. Appellant claims that the sentencing court erred by not conducting a new Huey analysis.
Well, and I see the green light is on. Would you please explain why Armstrong from 2020 does not require, despite what we said explicitly in that case, a new sentencing proceeding from the beginning?
Yes, a new sentencing proceeding was required and a new sentencing happened here. The court adopted its prior Huey analysis. There was an entire sentencing hearing that was conducted in conformance with Armstrong 2 from 2020.
Counsel, I'm going to press you on that a little bit because, and I'm quoting from the transcript, the court said, I maintain the same analysis that I did years ago because that's what is mandated here. I don't read anything in Ali as mandating that the court impose the exact same sentence. In fact, we said the opposite, do resentencing. So how does what the court did comply with our mandate in Ali or in the Armstrong precedent?
And as Your Honor said earlier when questioning the appellant, that's what the sentencing judge said at the very beginning of the sentencing hearing. But at the end, she did say that she was going to adopt the prior Huey because that was still the appropriate analysis that she conducted after having the entire hearing where she heard all of this supposed new mitigating
But
evidence.
can we really be comfortable that the court, in fact, did an entirely new analysis when I think it was twice. I maintained the same analysis because that's what's mandated, and then I resentenced according to the law court's mandate on that issue, keeping it consistent with my previous analysis. I mean, it really reads like the court maybe just misunderstood our mandate and didn't do a new analysis.
I would suggest that based on the sentencing hearing was at least an hour. There were multiple witnesses presented. The sentencing judge engaged with both counsel as to the issues brought up by counsel, and at the very end of all of that did say that she was imposing the same sentence because she believed that that Huey analysis was still appropriate. So I understand that she's used the word mandate in the transcript, but I would suggest that new, again, does not mean different. There's no requirement from this court or any courts, any of the jurisprudence here, that she was required to put on the record, basically reread her Huey analysis.
It says conduct a new Armstrong. In order to resentence on the merged conviction, the trial court was required to hold a new sentencing proceeding at which both parties could be heard and conduct a new sentencing analysis pursuant to the elements of the statute.
And I would suggest that that is what happened. She conducted a new sentencing analysis, and by adopting her prior sentencing analysis, after hearing all of that new evidence, she found that there was nothing that would change in her analysis and adopted that prior analysis, the original.
If we find that the court, in fact, our read of it is that the court did not conduct a new sentencing analysis, then do you agree under Armstrong that this would need to be sent back for another new sentencing hearing?
I do.
And should we not take comfort in the fact that there was a new analysis to the extent that before she got the section that Justice Lopez has referred to, her take on our mandate was this law court said nothing about the sentencing analysis being improper, which seems as if she's just going to then go with it because we didn't say it was what specifically, if anything, was wrong with it.
Obviously, I can't know what was in her head at the time, but I would suggest that she took in all of the new information that was presented by both parties, and at the end of that hearing, decided that her original Huey analysis still applied.
So here's, and that raises another. So what do we then to do? Go back? Obviously, since we were vacating the sentence last time, we had no reason to analyze whether the sentence was properly imposed. So do we now go back to the original Huey analysis that was used and talk about whether there was any basis upon which to, for example, aggravate the sentence for a showing of lack of remorse or lack of responsibility consistent with State versus Ellis? I mean, the suggestion is it's not there and that it frankly would be reversed in any event.
I would suggest that on the issue of remorse, that Ellis is not, as Your Honor said earlier in questioning the appellant, that Ellis does not require what counsel is stating that it requires. That in the transcript itself, there's much more to suggest that the lack of remorse in this case.
But my question is, are you saying we then review the sentence, the original sentencing process to see if there was error in ways in which that sentence was imposed?
Yes, I think that is what I think that there has been, if I'm correct about the procedure here, I think there was a discretionary appeal that was filed and merged into this.
Which, of course, so I take it you are backing off.
I am.
Your statement that propriety was not at issue.
Yes.
Which I found rather curious.
Yes, I didn't, I clearly missed that entry in the docket, Your Honor.
Okay. So let me ask another question. You have argued that when a case is remanded, quote, a remand order should put the parties in the exact same position they were in as if the case had never been appealed, not give appellant the benefit of the passage of time.
Correct.
If a case is remanded for new trial, are you saying that when somebody is resentenced after a new trial, the court could not consider what has happened in the intervening period of time, whether aggravating or mitigating.
I think a remand after a retrial, there is a different jurisprudence about what is allowed after that. And basically, a retrial gives you a blank slate.
And then what is the basis for asserting that one cannot consider the facts as they are today on the date of sentencing as opposed to how they were frozen in time several years ago?
The state's position is that that is a benefit that would accrue to the defendant that he didn't earn.
It may be, well, yeah, I don't know about it didn't earn. My question, though, was, is there authority for that assertion?
There's no authority in this court's jurisprudence for that assertion, but there's also no authority for the appellant's assertion that the sentencing court must consider and give the same weight to everything that he claims is mitigating.
In terms of consideration, I'm going to put aside weight, but in terms of consideration, if we're sending it back for a new Huey analysis, then the Huey and the sentencing statute controls, and there's nothing in that statute, I assume you would agree, that says the court must limit the time period, that it can't look at the last 2 years. So aren't we we're starting fresh? Why is that sort of not, isn't that the authority, what the statute tells the court to do at sentencing?
The court could consider, I suppose, whatever it wanted to consider, as long as there was a rational basis for the facts presented to the court. I think that was made clear in State v. Miller.
And I presume that, and we've said this is okay, but if in the interim Mr. Ali's behavior in prison had been very poor, I would imagine the state might alert the court to that and ask the court to consider that. Do you disagree with that?
I do actually, because I think that there is case law of this court's jurisprudence that says that the court is limited in what it can consider in terms of bad behavior, and that it's not just bad behavior generally in the intervening time between sentencing. It must be recidivism.
Well, okay, assume in the intervening time he had been convicted of something, you would certainly bring that to the court's attention.
Certainly.
Why can't the defendant also bring the good things then to the court's attention?
Because again, it goes to, on that third factor, on the third sentencing and third step of the Huey analysis, it is just further proof that the appellant or the defendant, the original sentence was appropriate, because it shows that the defendant is making good use of the sentence, the time that he was sentenced.
That sounds to me like an argument, counsel, that you might make to the sentencing court about why it ultimately shouldn't give much weight or shouldn't give a lower sentence as the defendant would be asking for. But it seems to me maybe you are agreeing that the court at least can consider the information.
I think on a new Huey, I think that the court could consider, but I guess the argument would be that it shouldn't be given much weight. And that's ultimately what the appellant is also asking this court to do, is to weigh in about what the court must and must not do when considering the weight of certain evidence.
You said a moment ago that it would be appropriate to consider crimes committed in the meantime, because that relates to recidivism, but limiting it to that. But in the Pierce case, we said the trial judge is not constitutionally precluded from imposing a new sentence, whether greater or less than the original sentence, in light of events subsequent to the first trial that may have thrown new light upon the defendant's life, health, habits, conduct, and moral and mental propensities. So that seems to suggest, coming around again, it's wide open.
That does seem fairly broad. I think later on in Pierce, or in a separate case that I quoted in my brief, it does say that it does limit that to recidivism, especially when the sentencing court is going to elevate a sentence.
But if you look at all of our jurisprudence, it isn't necessarily limiting it to recidivism. It just talks about identifiable conduct or misconduct, I think is the language that's used. But that doesn't necessarily mean commission of a new crime, does it?
Recidivism, I believe, would be commission of a new crime.
Misconduct.
Oh, I'm sorry, Your Honor, I misunderstood. Misconduct, I think, is broader, certainly, than recidivism.
Counsel, I think one of the arguments that you make as to why on remand the sentencing court should not consider new beneficial information is that it would set, and I'm just quoting from your brief, it would set inappropriate incentives to misuse the judicial system to circumvent proper sentencing procedures. Can you explain a little bit about why allowing the court to consider new information would result in that kind of result?
Certainly. I think that in a situation where there's a cognizable appeal but not ultimately a successful one, or there's a cognizable appeal and then the defendant is behaving well, the case is then sent back for resentencing on a technical error, it incentivizes defendants to find very ways to appeal a case that perhaps are not well-founded in the law. And so,
But what's wrong with incentivizing defendants to behave well? I mean, isn't that what we want them to do?
certainly, but not at the expense of judicial economy and judicial efficiency.
So I think what you're saying is there's an incentive to make frivolous appeals?
Right.
Well,
I asked Attorney Wentworth whether this created an anomaly here where people who get a resentencing, they've had some time in the meantime to do some good behavior, not really based upon the fact that they want to do good behavior, but they're coming back again, and they didn't express remorse the first time around, got dinged for that. Gives them a second go at it after there's been a trial run. Does that create an unfair advantage to folks who have an opportunity for resentencing if we kick the gates wide open, as they appear to be?
I would say yes. I would agree with that statement, that it incentivizes a defendant to take advantage of an error.
But if it's a frivolous appeal, it's not going to get very far, is it?
I hope not.
And if the court improperly weighed the fact that there was a lack of remorse, which, absent anything that the court points to specifically, other than not expressing remorse, we've called that to be an improper factor to utilize in purposes of sentencing, have we not?
I believe you have, yes.
Thus, if someone actually comes in to try to address that problem by expressing remorse, you find that problematic?
No. An appropriate appeal to this court is an appropriate appeal to this court. The concern is that there will be an increase in appeals, of frivolous appeals, Your Honor, in an attempt to utilize this loophole of better behavior to get a better sentence at the end of the day.
But that only comes into play if they are successful on appeal.
That's true, but it still increases the abuse of the process of filing frivolous appeals. I think that is a real concern if as Your Honor said, the gates were kicked wide open.
If you were to draft the language that you think should be the rule in these cases, what would it say? On resentencing, the court must.
I don't think the court should say that the lower court must do anything. I think this court, as is its jurisprudence, says that the lower court should consider all of the relevant factors as required in a Huey analysis. But that the court should only consider or give limited weight. I suppose what could happen is this court could say that courts should give limited weight in mitigation to conduct that occurred in between the original sentencing and resentencing.
Shouldn't we leave that to the discretion of the court as to how to weigh the information it gets in the context of a sentencing proceeding?
That would be, I think, the state's preference, but if the court was asking for a rule, that's how I would frame it.
Should we give it limited weight to the other way around for aggravating?
When there's new criminal conduct, new convictions, no, I don't think there should be any.
But we should if it's one way, so it should be asymmetrical.
Not asymmetrical, because an allegation is not a conviction, right? And so if there's an allegation of misconduct, I think that would get the similar limited weight on a resentencing. A conviction, however, for conduct in custody, I think would get additional weight. There are no further questions.
Any additional questions from the bench? No?
Thank you.
Thank you. Attorney Wentworth.
Yes, Your Honor. So, Justice Mead, I think I can craft a new rule
All right,
to
give it a
answer that
shot.
question. When resentencing a defendant, you have to actually hold a new sentencing procedure, which means going through a new analysis under Section 1602, which is what Armstrong 2 said, which is what the court should have done in this case, and it's what the court didn't do in this case.
So we haven't been explicit enough in our jurisprudence in the past?
I think you've been explicit enough, but apparently not for the sentencing court in this case. Because, frankly, we were shocked when we went to the sentencing hearing, and it wasn't just going to be a full new procedure and a new analysis. And so we were sort of caught off off guard by that because we thought it was so clear in this court's mandate that there should just be a new sentencing procedure. We would go through Huey, and if the court, weighed the factors differently than us, then sure, I suppose we could have still filed this appeal, and you likely would have been unfavorable to that appeal. But that's not what happened. The court just simply didn't do a new sentencing proceeding because the factors in 1602 are how you hold a new proceeding. And so it didn't do that. In terms of...
Well, just a correction. The court held a new proceeding. It just didn't do anything with the new information it received.
It didn't follow the procedure that is required by a sentencing proceeding. So I disagree, actually, that it held an actual sentencing proceeding, because to do so, you would have had to follow the analysis under 1602. And as it relates to this back and forth about recidivism and new information that can be considered by the court, in my reply brief, I addressed this, and this is longtime precedent by this court in State v. Weeks. This court adopted the rule that was announced in North Carolina v. Pierce, and this court summarized what new information could be considered. And it said that the reasons for an increase in sentence must be based on objective information concerning identifiable conduct on the part of the defendant occurring after the time of the original sentencing proceeding. I think the inverse of that can be true, where there's objective conduct that is favorable to the defendant that can then be used at the new proceeding. And so that's what was presented at the hearing. And so I don't think you can say you can only consider information that's bad for the defendant. If you can consider aggravating factors and aggravating information, you certainly can consider mitigating information. I think due process requires that.
Any additional questions from the bench?
Thank you.
Thank you, counsel. And thank you, counsel, for your argument here today. As is our usual practice, this matter will be taken under advisement and a written decision issued in due course. With that, we'll be in recess on this matter. seated. The matter before the court is Kennebec 25-465. This is, I'm going to probably mispronounce it, Fraumeni versus the Department of Environmental Protection and MTN. I see counsel are present. I've been given the allocation of time, so I'm aware of what that is. We are being streamed on the web, both by audio and by video. Before we begin the argument, I would ask counsel to please identify yourselves by saying your names for the record, together with the party you represent, starting with the appellant.
David Goldman for appellants Barbara and Michael Fraumeni.
Caleb Elwell for respondent, the Department of.
Morning, Ben Smith on behalf of MTN Sand and Gravel.
Thank you. And Attorney Goldman, if you're ready to proceed, we're happy to hear your argument here this morning.
Thank you, Your Honor. May it please the court. As I said, my name is David Goldman. I represent the appellants Barbara and Michael Fraumeni in this matter. This appeal is ultimately about two related questions. One is whether the Maine DEP, when faced with an application to operate a quarry, is required to substantively review that application to determine whether the information provided by the quarry applicant satisfies relevant performance standards for quarries, or whether, as the appellees would have it, MDEP is limited to determining whether the application form that MDEP itself created had essentially all the lines on the form filled out, so that the form itself can be considered to have been completed by the applicant, and leave it at that. So we submit that although 38 MRS section 490Y requires quarry permit applicants to submit a complete notice of intent to comply with MDEP before initiating quarry operations, nothing in that statute or in any other statute states that DEP is stripped of its general obligation to substantively review a permit application before approving it and to issue a written decision that explains the basis for its approval or denial of the permit. So the above procedural issue aside, the location of the quarry at issue here is undisputedly within an area that's been identified by the Maine Natural Areas Program as a focus area of ecological significance. Under 38 MRS section 490Z, if an area is listed under that program, then the quarry needs to seek a permit through the standards established by the Maine Natural Resources Protection Act, which the applicant did not do here. So on substance, no quarry permit should have been properly granted.
What is your understanding of what the position is of the DEP as to an area that is under the Natural Areas Program? Are there any?
I don't think that issue ever came up. It's not clear to me that any areas are listed from their point of view. I suppose I don't think they dispute that if there is an area that's listed, then it has to go through the Natural Resources Protection Act.
So I should ask the DEP this question when they come up and ask them if there are, in fact, any areas listed under the statutory language.
As far as I'm aware, they've never identified any areas. They've just said we're not one of them.
Counsel, you've said, an application to operate a quarry, reviewing this application to operate a quarry, they must substantively review a permit application for compliance, saying you have to apply for any kind of permit or apply to operate a quarry. Where are you getting that from? It says if you intend to do it, you must file a notice of intent to comply.
Right. And our position is that's just layered on top of, for instance, 38 MRS section 344 is just the general processing of applications statute. And it talks about,
But what is the standard? You're saying that even though there's nothing in 490Y that says you have to apply for a permit, there are performance standards, but there is nothing in the performance standard statutes that says you have to apply to the department for any of this, with some specific exceptions where it says the department, could give you something. I don't understand how you're coming up with that this is somehow a site plan review process that requires an application for a permit to do anything.
Well, First, obviously, our position is that because it's listed under MNAP, it has to go through the Natural Resources Protection Act standards.
Okay,
So
but this isn't, the notice of intent to comply is not to that it is to the DEP, the mining.
Right, but the statute does say, 490Z does says that the department may not allow the excavation to happen unless, the natural
Clearly, the
resource
department
protection.
has enforcement standards and can enforce not only subsection 1, but any of the subsections under 490Z.
Sure, and that is DEP's position, but in our view, that just proves too much. I mean, every situation out there, every land use permit ever granted.
Well, but you keep saying land use permit, and
Right.
is this a land use permit? There is nothing in the statute that says it is.
Well, it's land, the use is being made of it, and the general.
But there's nothing in the statute that says there's any permitting process.
Sure, but nothing in that statute says that. 38 MRS 344 just generally applies to all applications that are submitted to the DEP. And so, my view is you have to read these
But
two
again,
together.
you're assuming it's an application, and that's not what the statute says.
Well, I think the statute adds a layer onto the generally applicable requirement that permits be applied for. So if this wasn't an application, it should have been under 344.
So you're saying all quarrying activities, any expansion or change in a quarrying activity requires an actual permit and permitting process from the Department of.
It requires a permitting process that's informed by, 38 MRS, 490Y, and 490Z. Our view is that essentially the streamlining and the unique nature of the quarry application process is that, unlike with most land uses, you can go forward with doing what you wanted to do while the permit is being processed. So you don't need to wait you don't need to wait weeks, months, or however long it takes DEP to get through it.
So did the department, to your satisfaction, examine not only under, you're complaining about 490Z subsection 1, did they examine the standards under subsection 2, subsection 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13?
They did
So
not.
why is it only one that they have some obligation to do some kind of site plan review for?
No, I think if you apply for a permit for, taking my view of it, that section 344 applies to this, and it is a permit that they're applying for. If you apply for a permit, the DEP would, in our view of it, need to go through all those performance standards as part of the application process. And they need to make written findings saying, we saw this performance standard, we think you satisfied it because this meets the performance standard for whatever reason they articulate. I mean, they didn't do it in this case because, as I say, their view of it is that 490Z circumscribes their entire process, so essentially there is no review.
Do we give any, do we as a reviewing court or any reviewing court give deference to the department in its construction of how these statutes work together? And if they are owed some deference, don't we also have to look at the plain language of the statutes?
There's no doubt that under this court's jurisprudence, you do afford deference to the agency's interpretations when it's within a matter of the agency's expertise. And so the cases say we do not second guess an agency on issues within its area of expertise. So you wouldn't be second guessing an agency's determination of whether, how it interpreted the performance standards themselves and whether things were satisfying the performance standards as they interpreted it. But this is a question of what did the legislature mean when it said that some review process is applicable to quarries, not some technical question.
Right, but if the legislature drafted both 490Z and 490Y, wouldn't you expect there to be some cross-reference there?
There definitely be some cross-reference. All I'm saying is the question that's before the court right now is not a question of technical expertise that's within the kind of purview of administrators within the DEP.
Oh, no, just purely from a statutory construction perspective. Right. Wouldn't you expect the legislature to say in 490Y that the standards in 490Z must be accounted for?
And can I supplement that question? As I'm trying to make sense of 490Y also, I mean, 490Y is the green light, that's the go button. right? Do you agree it's a go button?
Yes, I do agree.
And down at the bottom, it points out the municipality where it was located may submit comments regarding the standards in 490Z. So the legislature's well aware of 490Z, but they don't throw it in at the top of the statute. It's right down at the bottom saying, you got the go button, you hit the light, you did this. The only way we look back at 490Z is if the municipality raises that question there. To me, that means that the go button is go, and if the municipality sits on its hands, it's not an issue.
Well,
I
let's
just don't
look
think
at
that-
some of the plain language.
I'd like to get, can I get your answer to my question before we jump to the next one? Thank you.
No, I just don't think that the legislature needs to directly in 490Y say, we need you to also pay attention to 490Z DEP when you're deciding whether to grant a permit to a quarry owner. because
But you
490Z
keep
comes
saying
right
grant a
after.
permit, and there's nothing in 490Y that says they have to grant a permit.
Sure.
That's the problem I'm having.
And this is where I bring you back to 38 MRS 344, which is generally applicable to all land use applications made to the DEP. It requires, and the generally applicable permit processing statutes, nothing here says they don't apply. It just says we are also creating this special kind of streamlined process for quarries so they can go ahead while you are processing the
Could the
application.
department decide they want a permit process for other kinds of land uses that aren't listed? Again, if there's nothing in a statute that says there's a permit process, but could they decide they want a permit process anyway?
I'm not sure. I guess I'm a little confused by how that would apply. My general point is just that there is a requirement to apply for a permit for land uses under Section 344. And so if the legislature wants you not to have to apply for a permit, it's going to have to say those requirements do not apply here, as opposed to saying, here's this other process in addition that applies, which is essentially what happened here.
Counsel, putting aside whether there's a general permit requirement, as I read 490Z, there is a permit requirement if it's in a listed area. That's your argument, right?
Yes.
And so I guess I wonder if you read that in concert with 490Y, under the department's position, it seems to me that sort of reads that permitting requirement out of the statutory scheme altogether. If they don't have to review that ahead of time, it's not really a permit. It becomes sort of an after-the-fact enforcement. Is that one way to sort of reconcile these two provisions?
I mean, it definitely reconciles it with respect to the areas that are listed, and it does raise the question of how do you even know that the area was listed or not unless you do some sort of substantive review. I just think that the process that the DEP has applied here is so circumscribed, it essentially is meaningless. It's just, were the lines filled in? And if they were, that's the end of the analysis.
Should we ignore the language of the actual placard that says it has been permitted pursuant to the performance standards for the quarries, 38 section 490-Y? Does that suggest it's a permit?
It does suggest it's a permit. It also suggests that some sort of analysis was done, which it was not here. But that also just further underscores the need for a written decision that says what did they consider important when they were granting this. If the answer is...
And they have to comply with performance standards, correct?
Yes.
And one of the performance standards is you need a NERPA permit if you're going to be located in one of these listed areas, correct?
Absolutely.
So you can't possibly comply with a performance standard if you're in this listed place without a NERPA permit, correct?
That is correct, Your Honor. Yes, I agree with that.
And what do we do with the communications that the department did have, in fact, with the Maine Natural Areas Program, where they indicated it's not a listed area under that?
I'm not sure that the...
I mean, isn't the department entitled to rely on that?
First, I don't think they used the words, this isn't a listed area. They had kind of, this is not regulatory, this is planning in nature. I also think that's just a statement of an individual. It's not necessarily a position of the Maine Natural Areas Program. It's just, this is all further why we need actual written decisions from the people who are making the decisions, so we can actually review it. But I see my red light is on.
Are there additional questions from the bench at this time? Okay, thank you. Attorney Elwell?
Thank you, Your Honors. The final agency action under review in this case is a notice of completeness determination issued on March 28, 2024. Contrary to the waived argument raised by the appellants for the first time in this appeal, this letter contained one key finding, concluding that a notice of intent to comply submitted by MTN pursuant to Section 490Y was complete, meaning that it included all the information required by statute. The Fraumenis do not dispute that this finding is correct. Instead, they ask this court to engage in oversight of the department's discretionary authority to enforce the separate performance standards contained in Section 490Z. In issuing this determination here, the department correctly performed the role assigned to it by statute, and this court should reject the appellant's request to read into the notice-based regulatory framework the legislature selected the very type of upfront application, permitting, and approval process the legislature deliberately rejected. And I welcome any questions from the court.
Why does the department issue a placard?
So my understanding is the placard is not mentioned in Section 490Y.
No, it's
Neither
not.
is the requirement that it be posted visibly at the entrance to the site. My understanding is, given the nature of this approval process, where an applicant is allowed, or a person who wishes to operate is allowed to begin operation before the department's even completed its review, and there's no permit or any type of official-looking document from the department to be issued, quarry operators were asking for something they could display to show that they were operating in compliance with the law.
So why do you have to give notice to the abutters?
I think the abutters do perform an important role in this scheme.
And what would that be?
They, as can be identified in this instance, both in the initial application where they did raise an issue with the
Saying you didn't fill it in the application
You
complete.
You didn't correctly notify the
So
abutters.
that's why you give them notice?
There's an additional rule which is also
Because they get to
demonstrated here.
comment too, correct?
Let him finish answering. I want to hear the
Thank you
answer.
for your assistance.
But I mean, I want to hear the answer too.
Please continue.
I think that this case actually exemplifies the role that the abutters can play. They can raise issues related to performance standards.
Why?
So that because our department does have authority to enforce those standards. There's not. I think the appellant has referred to the.
So if this was a listed area, you could say at that moment when they filed the notice, no, you need a NERPA permit? You
Yes.
could do that?
The department certainly could do that through its enforcement authority and the stop work order authority it has pursuant to the statute.
So they're given an opportunity to comment, but they shouldn't have, it shouldn't mean anything except because it's within your prosecutorial discretion to enforce the performance standard.
It certainly means something, and the department takes issues raised by abutters seriously, as they did here. They perform their duty to ensure that no violations will occur. And that if they're satisfied that there are no violations, that is properly an issue for enforcement discretion, as
What I
was the
think
case
I hear
here.
you saying, and I just want to make sure I understand, is that the role of getting comments, whether from the municipality or the abutters or any of these other things, is essentially, even though the quarry is allowed to operate immediately upon filing the notice of intent to comply, you're essentially front-loading a little as to whether there are enforcement issues that the department needs to take care of?
Yes, that's right. It gives abutters an opportunity to quickly identify potential issues that the department can then investigate and then stop, even before it's completed or reviewed the NOITC.
But that is a matter of enforcement, which may happen very quickly,
Yes, it might
as
happen.
opposed to permitting in advance.
Right.
Where do I find the list of areas that are listed?
So when the department reached out to MNAP, which is in the record at Appendix 190, to ask this question, MNAP referred to its list of rare or unique plants, animals, and natural communities. And that's a list they maintain.
It's a list of prioritized species. Where is the areas that are listed?
Well, the natural communities themselves are areas, and you can see an example of how these are listed if you look at the record at Appendix 131, the high-value plant and animal habitats. Just because of the nature of how species work, they list habitats where those species are known to occur. And if it's a rare animal, that would be an example of a place that might be listed under 490Z1. So if you look, there's a great blue heron habitat that's identified in a circle, kind of on the upper right near the site. There's a bald eagle habitat that would be a rare animal. There's some other ones along the waterfront, but they're all well outside of the project site as MNAP identified in its memo.
So who is responsible to issue a permit under 490Z subsection 1?
Well, if a permit is indeed required under
If one's
490,
required.
it would be the department's obligation because they administer the Natural Resource Protection Act.
And is there a separate application process for that, different from the notice of intent to comply for mining?
Yes, a Natural Resource Protection Act has, it's codified in section, I think it's 480 through 480Y or something along those lines. And there's a permit application you fill out, there's standards to be met. It's an entirely separate process by statute.
And does it say it's a permit that's required?
Yes. In that statute, the legislature clearly, as it is able to do, stated that in section 480D, under that statute, the department shall grant a permit when it finds that the applicant has demonstrated the proposed activity meets the standards, which is notably not language used in section 490Y.
Well, why did you say in the placard that it's been permitted?
As I was trying to explain earlier, my understanding is the department has issued these placards as kind of a supplement to the program in order that someone has something to display at their site to show that they are authorized by the department. And I think the language there is just a feature of how the department's able to input things into its own system, which requires the permit ID number. But I don't think it controls over the plain language.
And the
of
cover
Section
letter
490.
said, I have enclosed a placard that states your quarry is licensed. Is this a license?
I think the department would concede that the program together, the notice of intent to comply, which is a form of permission, the completeness review, a form of permission that is an exercise of the state's regulatory authority. I think that is a license.
It's a license. Yes. Okay, so this is a license. Thank you.
Which is why this is a final agency action and we're here on appeal.
And you indicated that this isn't a list, these aren't listed areas, that what are listed are habitats, significant wildlife habitats.
Well, significant wildlife habitat is a separately defined term, but they are, when they list rare animals, it's by areas where they're known to occur, is my understanding. So it's a discrete area of land, and you can see those identified on that map of high-value plant and animal habitats.
I'm sorry, I'm having a very hard time understanding how we are to assess whether the department has correctly applied the listed area statute or not. I sort of hear you saying that it's whatever MNAP says is listed. How do we assess that? I'm just still having a very hard time understanding what a listed area is, I guess. I don't quite understand your argument.
Well, I think part of that is because in the department's position is in this appeal, that's not a question that's properly before the court.
Well, I understand that, but assume that we think it is. How do we assess whether the department sort of did what it was supposed to do in this case and made the correct determination that this is not a listed area?
I think you can, the department's reasoning, I think, is pretty well reflected in the April 2nd email from mining specialist Michael Clark, where he explains why the focus area, which MNAP staff considered and informed the department they did not view as a listing, as that's considered, and instead they referred to the list they do compile of rare and unique plants, animals, and natural communities. I think that's the department's reasoning there, that this focus area, which the appellants refer to it as an MNAP-created focus area. I would say that's not entirely accurate because it's part of the Beginning with Habitat program, which you can see on those maps that are in the record. And that's run by IF&W and a host of other agencies that are identified in the bottom of those maps.
Is IF&W the sort of proxy for the federal government here? Because salmon are endangered species under the Federal Endangered Species Act. So does IF&W speak for the federal government here? Is there a separate notification requirement that the state should be undertaking to notify the federal authorities?
I can't say if the IF&W speaks for the federal government. They certainly would be aware of any issues that would trigger involvement of the federal government. do their
And
expertise.
IF&W signed off here.
Yes. They reviewed and they did not raise any issues.
Are there any other equivalent processes to 490Y that you're aware of, or is this a unique kind of exception to land use permitting?
Well, there's a relatively identical exception for borrow pits, which is essentially the same structure, and they were created at the same time. I'm not aware of any that are identical. It's somewhat similar to a permit by rule process, which the department employs, but it's not quite the same as that. It's essentially a unique program that the legislature created quite deliberately after a lot of discussion and input and kind of tailored to the needs of this industry.
Thank you, counsel. Attorney Smith?
Morning. May it please the court. In light of the questioning, I would like to focus on one of the particular issues that was raised by Justice Connors. Just to be clear, with regard to whether or not there has been an area listed, identified here, the answer is no. What MNAP determined was that contrary to the allegations of the appellants, the fact that the focus area exists.
Is there some determination other than the letter that's in the record? I mean, I think that's what the question is also.
And again, that goes to a deference issue, which I'll get to, Your Honor. But if I may, on the issue of whether or not this is actually in an area listed, you know, the statute basically does not provide very much guidance. It leaves it to the DEP's discretion to determine whether or not there is a focus area or other protected resource that is applicable here. The point about MNAP is MNAP was given this information by MDEP. They said, hey, here's the map, here's the area. Does this fall within an area that's listed? So MNAP had before it a location of the pit, a location of where things would be, and could have made a determination at that point, in keeping with what the appellants want, that the focus area itself would trigger basically a prohibition of the quarry. MNAP did not do that. And the reason that MNAP did not do that is because the mere fact that you have a focus area does not mean that it constitutes an area listed for purpose of the statute.
But where do I find the list published by the DEP on the focus, the areas listed pursuant to the Natural Areas Program, if not the focus areas?
Well, certainly MNAP, as you know by looking at 544, has the ability and does maintain a database of areas listed, and we know from Ms. St. Hilaire's memo.
Well, they have species, habitats, but that's in addition. It says effective land may not be located over a significant wildlife habitat or in an area listed pursuant.
And as the Superior Court found, the former two arguments with regard to any other area other than an area listed were really not developed by the appellants on appeal. I would point out that the record actually makes very clear that when you look at the actual habitat maps, when you look at the maps that have been created by the DIFW, and if you refer to our brief on page 32 in the footnote, the Maine DIFW is responsible for maintaining these habitat maps. We have provided, as part of our NOITC, all of these maps that demonstrate that there is no area listed in them. The only thing that comes close, Your Honor, is the fact that there was a forested wetland located to the west of the property.
So is it your suggestion then that this letter from Lisa St. Hilaire at MNAP Program or Information Manager is essentially a ruling that it's not a listed property?
No, that's not my position, and I don't think that would be the department's position either. I think that the fact is this is a notice provision in the statute. The arguments are really not proper before the court. To the extent that the appellants would like to have a different process furthered or would like to abrogate basically the process set forth in the statute, go back to the legislature.
Did the department look at any of the other performance standards under 490Z, some of which would require permits?
I don't think
In issuing under the notice of intent to comply.
I'm not quite clear. Can you please repeat? Can you?
I'm looking at the performance standards under 490Z. In addition to subsection 1, which talks about a permit if it's in a listed area, there are quite a few other subsections which may require permitting or variance, may or may not, depending on what the facts are. Were any of those looked at by the department in issuing that placard?
That's a question for the department. I will say that I think the department's position has been clear that given the sort of unique structure here, it's not required to do so.
Were there other permits obtained?
Outside of DEP, there certainly has been other, there have
Municipal, obviously. But.
And that may be a case that comes before you in a different way, Your Honor.
Do you agree that the placard's a license? Should we defer to the department's identification of it as a license?
I understand the time is terminated, and it's not necessarily a quick. I don't think it's a quick yes or no answer.
Okay, answer it.
Your Honor, I think that whenever you're dealing with this type of issue, when you're talking about either a permit or a license or other type of grant of authority, it's on a spectrum. Now, on the far easiest end of the spectrum, you have like a ministerial act by the BMV, for instance, in issuing a license. And on the far end of the extreme, I would say that you have a very complicated, maybe SLOTA, Site Location Development Act, NERPA approval, maybe Army Corps of Engineer. That would be like the NEC case that you saw a couple years before. This is somewhere in between. Now, is it a license? You can call it a license. It's certainly a grant of authority, but it does not change, Your Honor, what is required under the statute for them to be able to operate. In other words, you're still bound by what the legislature determined under 490Y, and the only requirement under 490Y is to provide an application. And in this case, I would say that the NOITC was complete. It was robust. It had all kinds of information in it, and the department determined it was complete.
Any additional questions from anyone on the bench?
Well, let's say that this was a listed area, okay? It is a listed area. Would you, but the DEP decides that's the enforcement, it doesn't have, can it still issue the placard and you can go on and quarry even if it's in a listed area?
Well, I guess the first issue I'd raise there is that, one, that's certainly not the case before us. It seems to suggest some sort of lack of good faith by the department that I don't think exists here. But the more important thing, Your Honor, to your point is, in this instance, the information that was submitted as part of the NOITC had all kinds of information included that demonstrated it was not an area listed. It had all the habitat maps. It had the plant value habitat maps.
Was that important to get the notice?
That was important for the purposes of the DEP determining, I think, as a threshold matter, is this in a area that either triggers a requirement for NERPA approval, or is it an area that could be, quote, listed? Now, the department, I think, in good faith and in exercise of its authority, consulted with MNAP to make sure that it was defining that term appropriately under the statute.
So your understanding of this process is, as a part of your notice application, you should include information that makes clear that it isn't in an area listed.
Ultimately, I'm not speaking to a hypothetical, Your Honor, as to what other case could come before you. I will say this: in our case, it is clear that we did submit that type of information, and the department had the ability to make a determination of completeness. I can't speak to what other application would fail.
Well, if you did give them that information and they did make it that determination, is that determination now subject to our review?
Well, we are here. Here's what I would say.
Well, but you don't have to stay here, so go ahead and answer that.
Your Honor, let me give you, if I may, an analogy to answer your question, if I can try. So, the fundamental issue here is that the appellants have basically asserted that this is a permit that can cause environmental destruction. It'll hurt our property. It'll impair us as abutters. There are many other ways in which the state, as a ministerial function, grants permits and licenses for activities that could be far more drastic. You think of an individual going to the BMV to get their CDL license renewed, and they have hazmat qualifications. That can cause huge catastrophes in the event that that person is not driving correctly or whatever. We don't necessarily say to the BMV, oh, before you issue that that license or you reissue it, make sure that you issue a written finding.
Well, one way to make sure you're not disturbing natural resources is to require a NERPA permit, correct?
And in this instance, there was no basis for a NERPA permit because it was not triggering the focus area language or the area listed language according to DEP.
Which is an issue in this case that we should review?
Your Honor, I understand that point. Now, the court is being asked to abrogate a provision in the statute, even though there's no invalidity being raised to the process in the statute. In other words, the court is being asked to essentially, as an extrajudicial function, impose additional requirements on the NOITC process that are not set forth in the statute, which is why we believe that that's an issue before the legislature, not before the court.
Any other questions from the bench? Thank you.
Thank you for the opportunity.
Attorney Goldman.
So I just think it's, leaving aside I don't want to be a broken record, but leaving aside my point that we don't actually have written findings that say what anyone decided to really review here. When you look at, on page 212 of the appendix, there's this memo from Lisa St. Hilaire, the MNAP information manager. It's just important to understand what their view of what these focus areas means and doesn't mean encompasses. They say in there that the comprehensive field surveys, they're in the process of saying, don't worry about it. They're saying, that said, comprehensive field surveys do not exist for all natural areas in Maine. And in the absence of a specific field investigation, the Maine Natural Areas Program cannot provide a definitive statement on the presence or absence of unusual natural features of this site. So that just underscores the idea that there's been laid out a large area that's been determined to be of ecological significance. And so if you want to put a quarry in that area, it's not that you can't do it. You just then need to go through the Natural Resources Protection Act process and show that your specific area doesn't actually have any of these, important botanical features, endangered animals, things of that nature. It just requires you to go through some sort of process, basically.
Well, what about their argument that at A131, those are the areas listed within the meaning of the statute?
Right, well, I guess that's a little at war with what the focus areas, that gets back to the definition of listed. And so the focus area materials on page 183 of the appendix itself says that there's a list of focus areas. This is a list created by MNAP. They may not like, the DP may not like that. Like I say in our brief, they can work with MNAP to change what is and is not a listed area. They can work with the legislature to change the language, but the fact remains, this is a listed focus area. And they haven't provided any sort of, I think, reasonable alternative to what listed means other than the materials that are listed by MNAP.
Any additional questions from the bench? Okay, thank you, counsel.
Thank you, Your Honor.
As is our usual practice, we will be taking this matter under advisement and issuing a written decision in due course. And with that, we'll be in recess on this matter.
All rise.
And good morning, you can be seated. The matter before the court is the Federal National Mortgage Association versus Jason Smith, Penobscot 25-389. I see counsel are present, I'm assuming ready to be heard. We are being streamed on the web, both by audio and by video. Before we begin the argument, I would ask the attorneys who are arguing to please identify themselves by saying your names for the record together with the party you represent, starting with the appellant.
Morning, Your Honor. David Massimino, Keeping National Association.
Attorney Patrick Hunt for Mr. Smith.
Thank you. And counsel, if you're ready to proceed, we'd be happy to hear your argument.
Good morning, Your Honors, and may it please the Court. My name is David Massimino, counsel for Appellants, KeyBank National Association. Today, this honorable court is presented with questions of procedural sufficiency, evidentiary sufficiency, and an impermissible deviation from longstanding historical practice for junior lien holders and foreclosure actions.
Well, counsel, I'm going to stop you right there since you've said you're going to allow the green light to be on right away. I understand this is a longstanding practice. And let me just say, 20 years ago when I became a trial judge, I started seeing these affidavits getting randomly filed in foreclosure matters. But frankly, I never knew why they were getting filed. And so I don't disagree that that's practice, but does that matter when it comes to applying procedure and the statute?
Your Honor, in this case, I think certainly it does, specifically because KeyBank National Association and their counsel relied on the procedure that had been applied historically in
What's
this
the
case.
procedure other than the fact that I always did it this way? The fact that you may have done it wrong doesn't make it the right.
Well, it is twofold. First and foremost, that it relied on it to its detriment up to the time of trial, certainly until after trial was held, that its affidavit was going to be accepted, and based its reliance on the representations of the court through the time of trial.
Well, the court never said it absolutely would accept that affidavit as evidence of the junior lien, right?
It said it was inclined to accept the affidavit up until even the day of trial, when it did not give KeyBank any opportunity to have a witness present, or even said that it was inclined to require witness testimony in contravention to typical practice up until that point. So when you're faced with typical practice of having an affidavit being the typical practice, and not having an affidavit and not having witness testimony be required at trial, not having any type of witness testimony required for a junior lien holder at a foreclosure trial, during which a junior lien holder typically does not present witness testimony, then a junior lien holder does not present a case in chief. In fact, most junior lien holders do not present themselves at trial at all.
Well, a lot of junior lien holders are judgment liens and things like that, where they know perfectly well they're never going to see a piece of it, so they don't bother too much. But let me ask you this. Is your argument that essentially you relied on certain, on past practice and on the lack of any notice that this would not be acceptable, and therefore it would be unfair to exclude the affidavit, or to at least not to give you another chance at it? Or is your argument that that is the correct procedure, or is it both?
It's both.
So what is the basis for arguing that it is the correct procedure?
The affidavit is acceptable evidence of KeyBank's.
Well, the affidavit is hearsay, so it's not evidence under the rules of evidence.
Well, the affidavit wouldn't be hearsay if reviewed by the court for.
How is it not hearsay? It's a statement out of court being offered for the truth of the matter asserted.
Well, if reviewed by the court under the hearsay rule, the court at that time would have been able to see that the affidavit as proffered would have fallen under a hearsay exception.
I have two questions about that. If a witness appeared and said what is set forth in the affidavit, then there is a basis for the court to accept that testimony and potentially rule that the documents are not hearsay and so forth. But that didn't happen here. There wasn't even an attempt to present the affidavit to the court during the course of the trial. Is the affidavit itself, if this affidavit were submitted in the context of a summary judgment motion, would it be proper? It simply avers that this is the affiant's free act and deed. Is that sufficient under Rule 56?
The sufficiency of the affidavit wasn't reached during the court's review. So,
well, the affidavit wasn't even presented to the court except through filing 6 months earlier.
correct.
Right.
So the objection to the affidavit wasn't fully reviewed based on the sufficiency of the affidavit itself.
I understand. All right. So I'm asking you today, as we're here, do you think this affidavit would satisfy Rule 56's standard?
So I believe that the sufficiency of the affidavit on its face is sufficient, and based off of the affidavit as presented, if it were to have been given review by the court, would have passed muster because it was presented with a business record language and was provided to the court with all the information that was required to be provided.
But it doesn't have a jurat that indicates that the affiant was swearing to the truth of the statements upon their own personal knowledge or when upon information and belief stated to be upon information.
That is included in the earlier part of the affidavit, within the text of the affidavit itself.
Your opposing party can't cross-examine the affidavit, though. I mean, a lot of times, as you know, in these cases, there are questions about irregularities that may have occurred or other financial, mathematical details. But if you can proceed simply by offering an affidavit, it's untouchable. It can't be cross-examined. And you're saying there's an unfairness issue for not being able to offer it, but isn't there an equal unfairness by offering an affidavit, which the opposing party can't possibly cross-examine? I'm trying to balance the fairness issue that you're teeing up.
So the issue here is that this is the plaintiff's case for foreclosure, and it's their case in chief for foreclosure. It is the court's responsibility to find for foreclosure as a case in chief, and it is then the court's responsibility, after finding for foreclosure, to distribute surplus funds. So what the court is finding then, after finding for foreclosure, whether or not the plaintiff has made their case for foreclosure, is only whether the parties in interest are entitled to their surplus funds. So what the parties
that's
in
not
interest...
it. I mean, Section 6322 says, after hearing, the court shall determine whether there's been a breach of condition, the amount due thereon, but also the order of priority, those amounts, if any, that may be due to other parties that may appear. I mean, the court is charged with not only determining priority, but the actual amount due to a junior lien holder after hearing.
Correct. But the order of priority of the liens and the amount of those liens were not at issue.
But who puts in that evidence? In other words, the court has a duty to determine, you're correct, but based on what?
Based on the affidavit that was submitted, but also whether or not those issues are on trial.
But the affidavit, as you're presenting it, is hearsay in the context of a trial.
Although you said there was an exception that you think applies, but I can't imagine what that is. If you want to identify an exception?
If we were to have gotten to that point, If we were to have gotten to the point of actually there being an objection to the
Assume there is.
affidavit,
Assume there's an objection because it's hearsay. What's the exception that allows it in?
then we would have gotten to then we would have been able to get to the point where counsels could have had an argument.
Well, I'm
based on-
asking you, what is the exception that would allow it in?
Then counsel would have made a business records argument.
But the business records exception still requires somebody to establish the foundation.
But at that point, Your Honors, having had a timely objection to the affidavit, counsel could have been prepared to present everything.
Counsel, you refer to a timely objection, but isn't it the case that the affidavit was never actually offered into evidence?
That is not true, because on multiple occasions prior to trial, Attorney Schaefer, who was representing Key Bank, noted both to counsel.
Well, I think I know where you're going, and he noted that the affidavit had been filed on the docket some 6 months before, correct?
Some 6 months before.
But at the trial itself, over the, I think, 2 days of trial, no lawyer for Key Bank ever got up and said, I'd like to introduce into evidence this affidavit.
He didn't say, I'd like to introduce into evidence, no. However, he filed the affidavit on December 16th, 2024. Then on February 19th, on June 4th, Attorney Schaefer, when counsel for Mr. Smith asked for default, Attorney Schaefer indicated that that the affidavit had been filed on December 16th and said, that is what we have filed and we should not be defaulted because the affidavit has been filed.
But that was an argument in response to a default.
However, he also noted that we filed everything that we needed to in order to preserve our.
But counsel, I guess my struggle with that is courts take all sorts of documents into their docket through, different phases of a case. You might have a summary judgment motion that's ultimately denied. There's all sorts of evidence, so to speak, on the court's docket that's been filed in connection with that. When you get to trial, the court typically starts fresh, right? The parties have to present evidence in the course of that trial. We don't look back to information that might have been filed on the docket before we get to trial. So what is different about this particular proceeding, that would allow Key Bank to say, well, we filed an affidavit just on the docket, really not associated with anything else, and the court should sort of take that into evidence at trial? What allows that?
Because Key Bank had established early on that.
Go ahead.
Because Key Bank had established early on that it intended for that affidavit to be its preservation of its interest. Because Key Bank's only interest in these proceedings was its preservation of its priority lien and the establishment of the debt owed to it. Otherwise, as to the foreclosure proceedings between plaintiff and Smith, Key Bank's interest in these proceedings was done. There was no cross-claim between parties. Otherwise, there was no intervention between Key Bank and the parties with regards to the foreclosure of the mortgage between plaintiff and Smith.
So can I follow up on what you just said? You said Key Bank early on established early on that it would rest on the affidavit to establish its junior lien. So do we take you at your word? In other words, if we decide that that really isn't appropriate evidence from which the court could determine a junior lien, you've made your choice, and so we would then be affirming the court on that basis. Is that right?
That's correct. However, if I may finish. However, I would also relate back to the fact that until these proceedings were finished and until the judgment was entered, the procedure that was known to all parties and conceded by all parties, including the court and counsel for Mr. Smith, was that junior lien holders, junior mortgagees, Maine Revenue Services, the Internal Revenue Services was to file these affidavits and rely on them throughout the course of these proceedings and rest their case at that point based on these affidavits. To do anything other than to allow a junior lien holder like KeyBank to file these affidavits and rely on that up until the time of trial and then walk away and then enter a judgment after trial saying, well, you didn't present a witness, so your lien is terminated without notice, amounts to sanctions in this case. If a change in rule were to be announced, such would have to happen with notice to KeyBank or any other junior lien holder.
I'm going to follow up on that. Is there a rule that you're asserting that says it is sufficient to file an affidavit?
The rule is the practice that has been established and acknowledged.
So there's
by
no
all
actual
parties.
rule. You're saying if you're going to change how we've always done it.
It is acknowledged by all parties that that is how it's been done.
Okay. Any other questions from the bench?
I have a question. If there were a change in practice, what sort of burden would that place on junior lien holders, and what would the effect be on foreclosure trials generally in this state?
I appreciate the question. The burden would be significant. So for junior lien holders, it would require then a witness for all junior lien holders. It would mean not only the participation in full in all trials that proceed in the state of Maine, not just for junior lien holders, but for all, not only for junior mortgagees, but for all junior lien holders, because presumably the rule would apply to all junior lien holders. Witness testimony is costly. Not all witnesses reside here in the state of Maine. And that cost burden would be subsumed within the cost of the lien itself, which means that essentially the cost would be added to the amount of the lien, the cost of the debt, and essentially be passed on to the debtor eventually. So if the cost of the debt was X, it now becomes increased by whatever the cost of that witness testimony was, whatever the cost of the preparation for that trial now was. If the presentation of an affidavit only cost $500, now we're talking about witness preparation, trial attendance, attorney's fees associated with that, possibly travel costs.
But counsel, isn't it likely that a lot of debtors will simply stipulate to the amount of the junior lien because they don't want to necessarily be tagged for the costs of having to establish it?
In other words, requests for admit interrogatory. Very simple. Say, do you agree this is the amount that's owed on the junior lien?
Having some experience in these matters, I can say that that has not typically been the case.
Well, it hasn't been the case because it hasn't needed to be the case, but the effect of this judgment has another consequence, it would seem to me, for KeyBank. Not only is a junior mortgagee or a junior lien holder entitled to the surplus after the initial mortgage is satisfied, but you also, a junior lien holder or a mortgagee also has a right of redemption, does it not?
It does.
And that right of redemption carries through the entire redemption period, so at any point during that period, the junior mortgagee could say to the senior mortgagee, I want to buy you out.
It can.
This judgment terminated that right.
It does.
Thank you.
Can I ask one more? This is just a procedural question. In this matter, there was a submission to the court, and as Justice Lopez referred, it's filed in the court file there. And toward the end of the hearing where the issue came as to what that submission was going to accomplish or do, I think counsel simply said that it was going to stand on its submission. Am I correct on that?
The submission of the affidavit.
The submission of the affidavit.
So that was the only submission, so it was the only submission that it could stand on.
So it says basically, no, we're going to stand on the submission. So what they're doing is they're saying, we're going to, something that's in the court's file that was submitted, we want you, the judge, to consider that, but never attempted to offer into evidence as an exhibit under exception to the hearsay rule or anything else. So really the issue before us today, boiled down to its essence, is can somebody who files a document, it's in the court file, comes to trial and say, Judge, we have nothing except something that's in your file. Does that even meet a minimum requirement for getting it before the court as part of the court record without offering it into evidence? You see the dichotomy I'm making here? Does something in the court's file create a status for that document that they can simply leave it at that without even at trial saying we're offering that as an exhibit?
I think, Your Honor, what a review of the transcripts in this case shows is that because there has been a pattern and practice of how these affidavits are treated in these cases, there is a significant back and forth and a misunderstanding of how this affidavit was going to be treated in this case. And there was not clarity from the judge in the Superior Court with what was expected from the parties in this case. In fact, there was a lot of lack of clarity in this case. In fact, there was in the transcripts that I've cited in my brief, there was I'm not inclined to default. What do you think I'm not sure what was, I don't think that was what I was going to do. I think that they've submitted everything that they needed to, and that was stated multiple times on the record. And so,
But I think that the judge at that point in the hearing said that basically anticipated that there might be a legal argument that the submission, the affidavit, is not adequate. So the judge is at least highlighting the fact that, okay, you're saying the fact that it's in the file and it's always okay in the other cases, and that might not be adequate. But at that point, there was no motion to admit it as an exhibit.
and at that point, that was on the day of trial.
Yes.
And at that point, KeyBank could not have had a witness there to do anything except for rely on that affidavit.
Okay.
So
it was never offered because it would be a futile gesture.
there was nothing KeyBank could have done at that point.
Okay. Thank you.
Anything further from the bench? Thank you. Attorney Hunt?
Thank you.
Can I ask, you've allowed the green light to be on right off the bat. I mean, I'm reading this transcript, and it doesn't feel like you ever actually objected to the consideration of the affidavit.
That's an excellent question, because I did not have to. It was hearsay. It was offered.
But you knew from Mr. Schaefer that it was being offered. I'm not saying whether it was properly being offered, but it doesn't, in reading this, Mr. Schaefer says, you know, we're going to rely on it. Everybody's been on notice. That's what we're going to rely on. We can argue about whether that was proper or not. But my question to you is, did you actually object to that? In other words, Mr. Doonan explicitly said that Fannie Mae consents to the use of the affidavit, and it seems like you didn't respond one way or the other. Is it a preserved objection?
It seems to me that I did at the end of the trial. Please call my attention to the paragraph.
Well, you have a statement earlier in the trial, well, I'm under the impression it had to be proven somehow, and that I'm aware in general it's done this way, but what if the bank asks for $1 million? People do make mistakes, but then you never really object to it.
Justice Murray on page 16 states, at the end of the hearing, defendant objected. The court's considers the affidavit filed with KeyBank.
I'm sorry, at what page of the?
Page 16
But
of...
that was at the end of the hearing, right? That was at the close, after the close of the evidence?
I don't know the exact point, Your Honor, but
I guess I don't have it.
He's referring to the judgment.
The appendix at page 60.
Oh, appendix, in the judgment you're talking about, not in the trial.
I think
Is
it's page 23 of the appendix.
23, thank you.
The findings of
You're
fact.
talking about the court's findings, not what, I thought you were talking about a transcript. I'm sorry.
I think during your closing argument, I think there was a reference to how the affidavit wasn't admissible because there was no way to challenge it. What if someone disagreed? What if someone said it was $1 million? But that was during the closing argument that counsel made the objection to the affidavit, correct?
Correct.
And before the closing argument, was there ever an objection to the court considering the affidavit?
No, because it was part of the record improperly. It was simply a tack-on or standalone document akin to a letter mailed to the court.
But
The court could not consider it because it was never offered.
you knew, didn't you, that KeyBank was intending to rely on that document?
No, I'm not really sure because
Well, you put in that, the night before the trial, you filed a motion to preclude KeyBank from presenting a witness.
a witness,
Yeah.
or did I say witness and exhibit?
Well, the point is, you knew pretty well, didn't you, that KeyBank was going to be relying on that affidavit. My other question to you is, did you actually have a basis for objecting to the affidavit other than hearsay?
The jurat was defective as the Chief Justice.
Other than that, did you have a substantive objection to the information presented in the affidavit?
It did not reflect a mathematical certainty as the plastic case requires how the bank, KeyBank, arrived at the payoff. And in addition,
So you would have cross-examined whoever the affiant was, Ms. Bartholomew, in the same fashion that you cross-examined Mr. Berenger for several hours at the trial. Is that correct?
correct.
And what did the court ultimately rule there?
Sorry?
What was the court's ultimate disposition with respect to that line of questioning?
That the business exception rule applied to Mr. Berenger. I also want to mention, if I may, that the bank officer describes herself as a bank officer, but does not describe herself as what type of officer. It appeared to me that the affidavit had been mass-produced, typical of what we called years ago a robo-affidavit, blindly signed and blindly mass-produced.
Are there additional questions from the bench?
But in addition, Your Honor, as I remember it, I don't think the affidavit was ever offered. It was part of the record.
Well, when you say part of the record, do you mean at trial?
Part of the file.
Part of the trial record, you mean? Not part of the court
It was
file.
sent to the court, but not,
It was mailed as a tack-on, as a standalone document, similar to letters. If you carried a logical conclusion, every letter a lawyer sent to the court would be an exhibit.
Well, you've done other foreclosure trials? Have you practiced done foreclosure trials? Is it your understanding or that this is typically the way junior lien holders preserve their rights?
You know, it's interesting, and thank you for asking that question. The foreclosure industry, first of all, the main banks, Katahdin, Bangor Savings, Camden, do a really good job. They have a really good job. The bigger the bank, the worse it gets. KeyBank was a local bank a long time ago. It's currently a Pennsylvania bank. The farther we get away from home base, the worse it gets. I've sat in many courtrooms and seen, not my trials, but the judges, we all know this, they're exhausted, overworked, underpaid. So what are they going to do? Ask the bank, the junior lien holders to prove things? So I think there's a practice of...
well, even inadmissible evidence comes in if there's no objection, right?
That's exactly correct. If no one objects, it comes in. Now, the next obvious thing is, what about writs of executions? It goes on and on and on. Sometimes we see foreclosures with 5, 10, parties in interest. So that's exactly correct. And I appreciate your comment. Thank you.
I'm not completely clear on your answer. So your answer is, yes, there is a practice that junior lien holders can simply file their affidavit.
Oh, yes, absolutely.
Okay, all right. I thought that was your answer. That wasn't clear.
So does that support then the bank's argument that this was really just sort of unfair, that they've followed a practice that's been widely accepted for a long time, and that if there were going to be a deviation from that practice, they should have received more distinct and clear notice that they needed to do something different?
At least given the opportunity to say, okay, if you're going to do that, can I have, can we return on another day? Can we hold the record open? All those
give me a
kinds of things.
chance to get a witness here.
Yeah.
Well, should Key Bank have a second bite at the apple? There's billions and billions of dollars of assets. My client from downtown Stacyville is practically homeless. Key Bank does not deserve a second bite at the apple. It has resources beyond belief. And while we're talking about that, it did not answer the complaint on a timely basis, did not file a witness and exhibit list. I objected, asked for sanctions, and it said, quote, we're not going to have any witnesses or any exhibits. Then it did not appear at the first hearing. The second hearing, it did not appear on the first day, but it appeared on the second day by way of Mr. Doonan, who appeared, entered his appearance the night before the second day and appeared magically by Zoom on the day of the hearing. Oh, you're here, by the way. Well, how many bites of the apple does Key Bank deserve?
So your position is that despite the sort of standard practice, which it sounds like everyone agrees has existed, it was up to Key Bank to understand that they needed to do something different? Is that your position?
Key Bank has enormous resources, absolutely. My client has no resources, zero, other than me.
And is there any argument that the court might have perhaps endorsed the past practice, or did make clear that the past practice wasn't going to be followed?
I don't think our judges have a duty to practice law for anyone except for people who appear with witnesses. Now, had I not objected, Justice Murray would have done the right thing. She would have granted Key Bank X amount of money. So unless someone objects, the judges have no duty doing it. They can't even practice law right before solar comes through the door.
And I guess going back to where we started, when did you object, in your view?
I think it's correct. I objected towards the end of it, but I had no duty to object because it was hearsay. It was a letter in the file.
Well, but counsel, let me just ask you a little bit about that. So, as was suggested before, you clearly knew that Key Bank intended to rely on the affidavit, right? Or at least they believed the affidavit was sufficient to establish the amount that was owed to them?
I believe Key Bank believed that.
Okay.
I don't believe I believe that.
Okay, but on June 4th, during a conference, you suggested that they should be defaulted, and then counsel for Key Bank reminded everyone that they had filed an affidavit, and then you said, well, can you email me a copy of the affidavit, and and then you said my request is withdrawn. So don't you think Key Bank could have reasonably taken from that you didn't have an objection to the affidavit being used?
I do not think so, because Key Bank had a duty to offer it at the trial, and there was no offer. It was simply a document that I had in my possession.
And then when you filed the motion in limine the day before the trial, you didn't mention the affidavit in that motion at all, correct?
I think I mentioned exhibits and witnesses.
But let me say it differently. You didn't expressly ask the court to not consider the affidavit. You simply said that Key Bank should be precluded from presenting witnesses or exhibits.
Correct.
Okay.
Because I had to blanket it. If I said the affidavit, it may have found something else.
Well, your motion actually said not be allowed to present any evidence or witnesses.
Okay,
Didn't mention a document or a particular exhibit or the affidavit.
Correct.
Just said witnesses or evidence.
Correct. And the affidavit would have been evidence, I think.
So if KeyBank had attempted to offer the affidavit at trial, you would have objected?
Oh, absolutely, absolutely.
And if they appeared with a witness that day, realizing that based on your motion, they needed to scramble and get something together, if they'd come forward with a witness, you would have objected?
I would have?
I'm asking, you would have
Of
objected?
course I would have, yeah. I've had some success with these cases, and I have a feeling for how the national banks operate, not like the Maine banks. You can't win a case before a Maine bank. It's impossible. They do it by the numbers. They do it the right way.
Any additional questions? Thank you, counsel.
Your Honor, if I may,
May?
also pending before the court is a motion for sanctions, and there was no response as required by Rule 10C, I think. So, in addition to the other 5 snafus,
There was a response, counsel. I have a response from the
you have a
bank.
response?
Yes,
I don't have a response.
It's dated April 23rd.
April 23rd.
Okay. You have responses?
Yes.
Yeah, I never received one. I'm sorry. Okay, yeah. All right. So what does that mean? I guess the court will make its decision based upon what it's heard today.
Okay. Thank you, counsel. And Attorney Massimino, you reserve 3 minutes for rebuttal.
Thank you, Your Honors. I was reserved 3 minutes. I'm not sure that I'll require all of it. But I do just want to mention that much of the argument that we've heard today has felt very amorphous, much like the objections to KeyBank's argument was rather amorphous. And I will just say that State versus Savage required that any objections to the KeyBank affidavit be made on precise grounds. And nothing in the transcripts that have been provided to this court indicated that an objection was made in a precise manner. And in order for the lower court to review such objection, as it noted that its finding in the judgment against KeyBank was based on Smith's objection, it needed to be made on a precise ground. And the lower court's findings of fact and conclusions of law indicated that its finding was based on Mr. Smith's objection. And I struggle to see.
But if the objection, even if the objection isn't precise, even if it was just objection without even saying why, if the judge's ruling and excluding something is correct, isn't that all that we ask for?
However, its findings of fact and conclusions of law indicated its reasoning for its finding. And its reasonings for its finding indicated that based off of his objection, it found that that affidavit evidence is only helpful or can only be used in support of a motion for summary judgment and cannot be used at trial.
I'm looking at the courts, I'm literally at that language there. And my question is, what are we to make of the alleged practice that this was sufficient? You said that was a practice that was accepted. Opposing counsel says emphatically, yes, that's practice that's accepted. We see the court finding as a finding here that, yeah, it's a practice, it's appropriate in summary judgment matters, but I'm quoting, affidavits are accepted in connection with motion for summary judgment, but when a case proceeds to trial, evidence from a witness is necessary, absent agreement to the admissibility of the affidavit. So the court didn't make a finding that there's a practice at trial to allow the exhibit, the affidavit, although it is in summary judgment proceedings. Are we to take counsel's statements here today into consideration? Yes, there was a practice to allow affidavits for junior lien holders in trials. What are we to make of that?
I think what we're to make is that there has been incongruous statements throughout the course of this trial and this case that don't align with the court's judgment and findings of fact and conclusions of law. So what the transcripts show occurred throughout the course of this trial are at complete odds with the judgment and the findings of fact and conclusions of law. They just don't match.
Thank you.
Any additional questions from the panel?
I do have a question. Your argument rests to some extent on the failure of a proper objection having been made. The motion that was filed the night before the trial, though, requests a motion limine as to KeyBank that it not be allowed to present any evidence or witnesses at the trial. Is that not an objection, essentially, to the affidavit?
I would definitely indicate that that is not an objection to the affidavit. I think it does not state any specific grounds that the affidavit is objectionable.
Did KeyBank respond to that?
It did.
And what, I don't have it in front of me, but do you remember what the response to that objection was?
Yes. The response to that motion was to indicate that it does not intend that it did not file a witness and exhibit list because it had already filed an affidavit which was consistent with the pattern and practice of junior lien holders in foreclosure actions, which is to file an affidavit of debt or an affidavit of a third party to preserve its lien interest and to provide the court with evidence sufficient to provide the court with information to issue a judgment proving the amount of debt owed to a third party lien holder, and that therefore a third party, a party in interest, does not need to provide a witness and exhibit list and would not need to provide further evidence at the time of trial, and so it would not need to provide further evidence on the day of trial or a witness and exhibit list, and should not be subject to sanctions.
Thank you.
Any additional questions? Okay, thank
Your
you.
Honors.
As is our usual practice, we will be taking this matter under advisement and will issue a written decision in due course. I also understand, counsel, that this is your first appearance in front of this court, and it is our custom to ask counsel to come back into the conference area to take the greetings of the court upon a first argument. So we look forward to meeting with you.